Be ready. Start. In light of these extracts, we are in agreement with the respondent claimant that the presumption mandated by Section 139 of the Act does indeed include the existence of a legally enforceable debt or liability. Stop. To that extent, the impugned observations in a case may not be correct. Stop. However, this does not in any way cast doubt on the correctness of the decision in that case, since it was based on the specific facts and circumstances therein. Stop. As noted in the citations, this is, of course, in the nature of a rebuttable presumption, and it is open to the accused to raise a defense wherein the existence of a legally enforceable debt or liability can be contested. Stop. However, there can be no doubt that there is an initial presumption which favors the complainant. Stop. Section 139 of the Act is an example of a reverse onus clause that has been included in furtherance of the legislative objective of improving the credibility of negotiable instruments. Stop. While Section 138 of the Act specifies a strong criminal remedy in relation to the dishonor of checks, the rebuttable presumption under Section 139 is a device to prevent undue delay in the course of litigation. Stop. However, it must be remembered that the offense made punishable by Section 138 can be better described as a regulatory offense, since the bouncing of a check is largely in the nature of a civil wrong whose impact is usually confined to the private parties involved in commercial transactions. Stop. In such a scenario, the test of proportionality should guide the construction and interpretation of reverse onus clauses, and the accused oblique defendant cannot be expected to discharge an unduly high standard or proof. Stop. In the absence of compelling justifications, reverse onus clauses usually impose an evidentiary burden and not a persuasive burden. Stop. Keeping this in view, it is a settled position that when an accused has to rebut the presumption, and the standard of proof for doing so is that of preponderance of probabilities. Stop. Therefore, if the accused is able to raise a probable defense which creates doubts about the existence of a legally enforceable debt or liability, the prosecution can fail. Stop. As clarified in the citations, the accused can rely on the material submitted by the complainant in order to raise such a defense, and it is conceivable that in some cases the accused may not need to adduce evidence of his oblique her own. Stop. Thus, it has been settled that there is a presumption in favor of the complainant and against the accused that the check was issued for consideration. Stop. However, the presumption is rebuttable. Stop. The accused can prove that the check was not issued for consideration and that the accused did not have any liability to pay the amount. Stop. It has also been held that the accused need not lead evidence in support of his defense. Stop. He can prove it on the balance of probabilities by showing the contradictions in the material produced by the complainant. Stop. In the present case, the accused has admitted his signatures on the checks. Stop. It is also admitted that the checks are drawn on account of the complainant. Stop. It is also proved that the checks were presented for encashment and that they were dishonored. Stop. The accused has, however, disputed service of legal notice. Stop. It has been argued that there is no material on record to show that legal notice was duly served upon the accused as per law. Stop. I have considered the submissions. Stop. However, there are no merit in it. Stop. The complainant has filed the copy of legal notice and postal receipt. Stop. The postal receipt is not disputed. Stop. The accused has also not disputed that the address mentioned on the legal notice is not his address. Stop. Once it is shown by the complainant that he had posted the legal notice at the correct address of the accused, the requirement of law stands satisfied. Stop. No further proof of service of legal notice is required. Stop. The duty of the complainant was to give a legal notice. Stop. He has proved that he had given a legal notice to the accused under Section 138 Negotiable Instruments Act. Stop. Hence, he has discharged the burden. Stop. It has been proved that complainant had issued a legal notice under Section 138 Negotiable Instruments Act within limitation period after dishonoring of the check. Stop. The complaint is therefore maintainable on this aspect. Stop. I get strength from the judgment of the Honorable High Court of Delhi. In this case, stop. In the above said matter, before the Honorable High Court of Delhi, one of the ground of defense taken by the accused was that legal notice under Section 138 Negotiable Instruments Act was not served upon him as it was not sent at the correct address of the petitioner. Stop. The Honorable High Court of Delhi, while dismissing this ground, has held that service of summons in such cases can be considered as service of notice, and drawer of the check is having option to make the payment within 15 days of the receipt of the summons of the court along with the copy of the complaint under section 138 of the act. Stop. The Honorable High Court has held as under. Stop. Other limb of argument advanced by the counsel for the petitioner is that the legal notice sent to the petitioner was never received by the petitioner, as the same was never sent to the correct address of the petitioner. Stop. Perusal of record shows that legal notice exhibit CW 1/9 was sent on two addresses of the petitioner. Stop. The legal notice sent to the former address was received back with the report that the addressee had left the address. Stop. Whereas the notice sent on the latter address was not received back. Stop. The contention of the petitioner is that his address was never of Lajpat Nagar. Stop. Even if, for the sake of arguments, it is believed that the address was not correctly mentioned on the legal notice, the judgment of Honorable Apex Court in the case makes it clear that if a person does not pay within 15 days of receipt of the summons from the court along with the copy of the complaint under section 138 of the act, cannot contend that there was no proper service of notice as required under section 138 of the act. Stop. Relevant para from the judgments is quoted here under. Stop. It is also to be borne in mind that the requirement of giving of notice is a clear departure from the rule of criminal law, where there is no stipulation of giving of a notice before filing a complaint. Stop. Any drawer who claims that he did not receive the notice sent by post can, within 15 days of receipt of summons from the court in respect of the complaint under section 138 of the act, make payment of the check amount and submit to the court that he had made payment within 15 days of receipt of summons by receiving a copy of complaint with the summons, and therefore the complaint is liable to be rejected. Stop. A person who does not pay within 15 days of receipt of the summons from the court along with the copy of the complaint under section 138 of the act cannot obviously contend that there was no proper service of notice as required under section 138 stop.